Hi everyone, Joe Gentili from Sarraf Gentile LLP. Want to talk today about some tips related to delayed employment-based immigration benefits. So probably the most common situation that we deal with in this realm is somebody went overseas and is waiting to get their H-1B stamped. That's a pretty common scenario, but this really applies to anything. The tips are going to apply to anything that has to do with delayed employment-based benefit. So it could be related to H-1Bs, it could be related to Ls, applies pretty broadly. So one thing that we come across a lot is that employers are frequently reluctant to put their name on a lawsuit. And this is relevant because there's some case law out there that says that in order to have standing to bring a lawsuit, the sponsor has to be the plaintiff in the lawsuit. It can't be the beneficiary. Fortunately, that position is in the minority. Most courts have held that beneficiaries have standing to bring a lawsuit on their own. So I would say in most instances, this doesn't turn out to be a major issue in a case, but if you were to set up things going forward perfectly, you'd want to have the sponsor and the beneficiary be plaintiffs in the case. So that's why it's relevant. It's not necessary to have the sponsor, but it's better. Even if it's only slightly better, it's still better. And I think sponsors or employers are frequently worried about publicity, or they're worried about retaliation from the government. And there are a couple of things that we suggest for both of those. So first, with regards to the publicity, Mandamus lawsuits generally aren't newsworthy. They're not a big deal. They're not something that gets blasted on the Wall Street Journal unless you happen to be a celebrity or something like that. Bringing a case, it's generally not newsworthy. Second thing to remember is that if you properly mark immigration cases, they are still publicly available like any other case, but the details of the case are only available if you go to the courthouse, and they're available analog, not electronically. So yes, somebody can get the details if they want it, but they do have to go through some effort in order to get it. So that's going to discourage most people because you can't just click on something online and all the details of the case come up. Third, if you're strategic, you could also just kind of limit how public the company's involvement is. And one way to do that is when you have a caption and you have, Joe Smith versus USCIS, or Joe Smith and, pick Fortune 500 company versus USCIS. If you put Joe Smith first in the caption instead of Fortune 500 company, the case gets reported as Joe Smith versus USCIS. So the name of the company may not necessarily come up in the reported caption. So there's strategies that we could have to try to minimize the publicity of it, or even how easy it is to find in a search. But generally, mandamus cases aren't seen as a big deal or all that newsworthy anyway. As far as retaliation goes, it's not really a thing. I haven't heard of, and other colleagues that I've spoken to, conferences I've gone to where people have discussed these cases, I haven't heard of a single instance brought up where a company or person, for that matter, has been retaliated against by USCIS for filing a mandamus lawsuit. So, it's one of those things that we can never say it's impossible. You could walk out your door on a sunny day, and I suppose it's possible at some point you get hit by lightning or whatever. But it's just not something that we've heard of happening before, and I don't think it's very likely at all that retaliation is going to occur. So one other thing that we recommend is after all of this, if the sponsor is still just unwilling to put their name on a lawsuit, which is pretty common, one thing we suggest, and we do get this a lot, is to have the employer or a supervisor or somebody at the company write a letter to say that the employee, the immigrant, is an important plays an important role in the company. Their absence is really missed. It's hurting the company. Just basically laying out just how important it is for the company's business and, for benefiting their operations in the US to have this person here, and these delays are preventing that. Companies are usually willing to write that letter. We won't necessarily file the letter as part of the lawsuit, so it's not something that'll be publicly available, but we will share it with the US Attorney's Office that's defending the lawsuit. And I think they're helpful. They're helpful because, number one, if it's a large company and there's a lot of jobs at stake and there's a lot of money at stake for this person's involvement with the company, I do think that has some sway with the government. They have an interest in the U.S. economy, especially the economy in the local area where we're filing the suit, that it does well. So I think that does help. But again, it's not something that's necessary. So, best case scenario, you have the company be a plaintiff in the lawsuit. If you can't have that, the next best thing is they're not on the lawsuit, but they're willing to write a letter that we could share with the U.S. Attorney's Office. If they're not willing to do that, you could still go forward just filing the case on your own behalf as the beneficiary. We've done that a number of times and we've gotten successful outcomes doing that. So if you can't get cooperation from your company, it's not the end of the world. As long as they're still willing to sponsor you, it's not the end of the world. It's still a very viable case in that scenario. But these are just some thoughts on a topic that comes up pretty frequently when we're dealing with employment-based delays. So as always, if you have any questions, feel free to reach out, and I hope this video is useful. Thanks for watching. Bye.